All right, we're gonna start. So, again, welcome to Ask a Lawyer workshop series. Today is the first of the series this year. And Ask a Lawyer series is a collaboration between the Sacramento County Public Law Library and HERA, which stands for Housing and Economic Rights Advocates. My name is Irene, and I am a staff attorney with HERA. Today, I'm joined by my colleagues Michael and Cassie, who will be supporting me and helping me check the questions that may come up. And if you have questions throughout the webinar, feel free to type it up in the Q&A box, and we will have a time to address questions at the end. Um, so, so today, the topic is Estate Planning 101. Thank you for joining and wanting to learn about this interesting and important topic. And since it's a 101, I'll get to the disclaimer real quick. We'll talk about the what, who, when, why, where, real quick. And well, kind of in detail, not that quickly actually. We will dive into the details of what, who, when, why, where. But before that, let me give a disclaimer. Today's presentation is for informational purpose only and does not create attorney-client relationship between the participants and the Sac County Law Library or HERA. And if you would like to know more about the resources we offer, we will have a slide for that towards the end. Real quickly, HERA is a California statewide nonprofit legal service and advocacy organization. Our mission is to ensure that everyone is protected from discrimination and economic abuses, especially in housing. So we provide free legal services and counseling for tenants, homeowners, and on topics related to foreclosure. And today's topic is estate planning. For estate planning, we added that service a few years ago after realizing in order to really protect people's housing rights, we want to protect that right for generations, not just for just one generation. So estate planning is crucial to achieve that goal. And I went through the basics of where we're gonna go. And before we dive into the meat of the presentation, I will have some back and forth, I guess, interactive questions, true or false questions to help all of us get more engaged. So first of all, you might have heard people say, I don't own anything, therefore I don't need estate planning. Isn't that for rich people only? Do you think that's true or false? You can think about that for a minute. So it's false. I'm not sure if it's surprising to you or not, but even if someone doesn't own anything in their physical possession, that person still has himself, and planning is needed for potential incapacity later in life, which we will talk about more very soon. Okay. Second question, I have three children, Omar, Oscar, and Olivia. I can leave my house to just Oscar. Is that true or false? When I give this presentation in person, I get mixed answers for this one. And this one is true. You just have to make sure you write it down clearly in writing. So have something to show that intention. All right, the next one. I have a written will. My child does not need to go to probate court when I die. This one is tricky also. And the answer for that is false because having a will and the court will want to make sure the will is valid and there's no fraud, no defect in the execution, and if it's valid, the court will try to honor that will. But that whole process is what the probate court does. All right, last one. My children get along so well, so I don't have to worry about anything. So I think everybody knows this is a false one. All right, so we're gonna go through our first WH question. What is estate planning? Estate planning is not just a set of papers. It's a process that involves your loved ones and your treasure. It addresses your future needs. A will, which is most people have heard of the will, is part of the planning process, but you also need other documents to fully address your estate planning needs. So for estate planning documents, the packet usually comes with both inheritance planning documents, which is wills and trust, as well as incapacity planning documents, which is power of attorney or POA for short, and advanced healthcare directive, or in some other states, it might be called POA for healthcare decisions. And during lifetime, when you are alive and well, you can set up these documents, and you should set up these documents, and you can feel free to change the contents inside. It's up to you how many times or what kind of changes you want, or no change at all, completely up to you. But after date of death, the incapacity planning documents are no longer relevant. What's left would be the inheritance planning document, which is trust and will. So you see the yellow bubbles on the right, they become final and irrevocable at that point. So just some idea on what documents are involved and the timeline, or the date of death is like the really important date. All right. And then after knowing the what, now we want to say why. Why do I need estate planning? As I have alluded to, it's for dual purposes. For incapacity planning during lifetime, where you designate someone you trust, ideally more than one person, with one primary person, several backup people who can help you manage your assets and make sound healthcare and personal care decisions when you become not able to do that for yourself. And the second purpose of estate planning is for post-death planning, which is also called inheritance planning or legacy planning, where you can determine what happens to your treasures after you're no longer around to enjoy them, and who are the people that you want these treasures to go to, and who are the people that you trust enough to see this process through. So that is the post-death planning. All right, so we tackled what and why. Now we want to talk about when. All right, so we will split the discussion into inheritance planning, which is when you are gone, and then later we'll talk about when we are still around, the incapacity planning. All right, so when you're gone, what happens legally speaking? Something called probate might be relevant, depending on whether you have planned or how much you've planned. So in the probate code in California, it talks about the threshold. So the total value of the things that you own on date of death altogether gross value. So I underline here gross value, whether it's above this figure here, which is 208,850. I'm trying to get familiar with this number because it's very recently updated. As you can see on the bubble on the left, that this number is effective April 1st, so last month. So before April 1st, so people who passed away before April 1st of this year, the threshold is lower than this figure, but this is the current figure. So yeah, so on date of death, that's the date of valuation. How much does the estate of this decedent is the estate worth? That's the date that we look at, and we look at the gross value of everything the decedent has left behind. All right, so that's the probate threshold. And then there are assets that are not subject to probate. And frankly, some of them then become estate planning techniques because we're trying to avoid probate or trying to stay outside of court when it comes to something so private, something so personal. All right, so the first bubble here, assets not subject to probate, would be property held in the decedent's revocable trust, which we will talk in more detail. And that's why people do the trust, so that they can put money and house and other things into this trust, so that things held by the trust can be shielded from probate. The second bubble here is real property held in transfer on death deed, which I will talk about later too. That's also a exception to probate. And the third bubble on the top level talks about multiple party account, POD account, total trust account. So these are accounts where there are several people on there, and several people own the money held by the account together. So when death occurs, the remaining owners of the account will share equally whatever that's left. So as long as somebody's still around who owns the account, just because a co-owner passed away does not trigger a probate. So that's the third one. And then the fourth bubble is what I was talking about, the threshold of probate, where a decedent's assets, wealth, treasure, everything added together, the gross value, doesn't matter if there's still a debt, gross value is under 208 and then $208,850, then it's shielded from probate. All right, and then I'm gonna go to the second level. The fifth bubble, the bubble on the left bottom, property held by the decedent in joint tenant. So this is where you see, for example, a grand deed where it will say husband and wife hold the property as joint tenants with rights of survivorship. When you see that language that mentioned joint tenant, that means as long as somebody is alive, the property doesn't have to go through probate yet. So when everybody pass away, then probate will have to happen. But until then, it's good. And then the middle bottom bubble is essentially the same to the one that I just talked about. This one is property passing to surviving spouse or registered domestic partner under that code section there. Same idea. As long as somebody's still surviving, the property doesn't have to go to probate until everybody that jointly own this property pass away. And then lastly, retirement/death benefit property with beneficiary designated. So you probably already know for all your accounts, it's a good idea to designate beneficiaries, and especially for retirement and death benefits account, IRA, 401k, 403b. It's crucial to have someone designated as the beneficiary, and the whole account then is no longer subject to probate, which is good news. All right, so I'm going to talk specifically now about the first bubble, property held in the decedent's revocable trust. I'm going to try my best to demystify this thing called trust. When you come across a revocable trust, you will encounter these terms. Just listing them out right here isn't trying to intimidate you, but hopefully now that you have seen this once at least, later when you encounter them again, they're no longer so new and intimidating. So you'll come across these different roles that are in the trust. That would be trustor, which sometimes is also called settlor, grantor. You'll see trustee, and you see beneficiary. So what are the differences? Trustor is the person that sets up the trust document. So that person is the only person, or if it's a married couple, the only people that get to decide if they want to make any changes later or not. No other role has the right to change the trust itself. Trustee is the role that sees through inheritance, like how that's divided up according to what the trust says. Beneficiary, self-evident, is the person that benefits, the person that inherits, the person that gets the gift from the decedent. And revocable, intervivals, trust, living trust, same thing. Intervivals and living are the same thing. So you can imagine this trust document a living, breathing document where as long as the trustor is around and healthy, that person can update the document depending on life circumstances and things changing. And so it's a living document in that way. And the next one is pour over will. Pour over will is a will that goes along with the trust. And it's I imagine this to be a teapot. So the will is a teapot, the trust is a cup. So pour over will is whatever property that should be governed by the trust, somehow left outside of the trust. I want to pour it back into the trust. So that's the pour over will. Having the trust still take care of how it should be distributed. And then trust agreement, declaration of trust. So you'll see these languages there. And common provisions. It includes clauses that identify family members, but you don't have to name family members as trustees or beneficiaries. But they do get mentioned on the first page usually, like who your family members are. And then there are provisions that go into detail about your designation of trustee and successor trustee. And then, of course, the most important probably clause is the distribution clause that talk about what kind of gifts that you are setting up and who gets what at what time. And then there's also other provisions such as trustee compensation, accounting, spendthrift clause, no context clause. So a lot of these provisions are quite boilerplate. They're in everybody's trust document, and it's a good thing to bring up to the attorney that you work with and ask questions about when you set the document up. So those are the common provisions. And then I'm going to talk about advantages from the trust when we compare, trust against no trust. So as I briefly mentioned, if somebody has a will without a trust, probate is still necessary. So the whole right side is the will/no will probate side. And then the left side is living trust. So this is a chart of comparison. Let's see the differences. Obviously, with living trust, no probate is needed. On the right side, probate is needed. For living trust, it's a private record. It's a private document that nobody needs to know the content of. They don't have a right to know. Only you have a right to know as the trustor. And it's up to you how much you want to share with your beneficiary and trustee about what goes in there. But a will, after somebody passing away, the last will that this person has completed, assuming it's valid, would be the public with the standing version, and it will be a public record. Therefore, that's why when celebrities pass away, sometimes you know exactly what's written in the will, because it's a public record. Very big difference here. Next difference, living trust. Having a living trust, there is no legally required or statutorily guaranteed fees to successor trustees and attorney. So that's something that is there on the probate side, where there's a legally guaranteed compensation for the executor or the personal representative and the probate attorney, which I will have more details on down the line. So that's a money difference there. And then the fourth difference is that with a living trust, the successor trustee can do all the tasks as the trustee without having to gain court approval or supervision. But on the probate side, the executor or the person representative, they have to do all tasks under court approval. Sorry, under court approval and abide by court deadlines. So that's also very different. And then the next one is that after January 1st, 2017, the law had changed where if you use Medi-Cal during lifetime, you typically have a worry about something called estate recovery, where after the Medi-Cal recipient passes away, there's a chance that the Department of Public Health, forgot exactly what the department is called, would want to recover from your estate the money that they had spent or you had used through Medi-Cal. So after 2017, only assets that are not subject to probate, only assets that are subject to probate will be subject to that estate recovery. So what this means is if you have a trust and have the trust manage the properties, then they are not subject to probate and therefore not subject to estate recovery. So that's pretty significant if you use Medi-Cal benefits. All right, then so at the end of the day, on the living trust side, it's more money and shorter time, fewer beneficiaries. Whereas on the probate side, it's less money and more time. And sometimes you might end up giving things kind of to stranger-like relatives, like unwanted arrangements might happen. All right. Next, I'm gonna talk about will briefly. Will, similar to the trust, contains your wishes and your desires about who receives your assets after death and who manages that estate. But very, very differently, with just the will, probate is still needed as the court needs to validate or try to see if the will is valid. And then we've been talking about probate like probate is a monster. What is probate? Um, it's a court supervised process for transferring a deceased person's estate to the beneficiary named in the will. Um, and part of that process is validating the will. And the court also appoints a personal representative. Um, and sometimes that role could be called something else, but essentially the same. And then if there is no will, distribution of the properties could be made according to the probate code. So as you can tell, okay, probate isn't really a monster, but why are we trying to avoid it so much? Um, Essentially, it's using a lot of the public resources, and it's costly anytime you have to engage public resources. And also, it might not do what you intended in the first place because, especially if there's no will, distribution will happen according to what the law says. And the law has a one-size-fit-all cookie cutter solution, which might not, most of the time, does not fit each individual family's needs and dynamics. So, just a little flavor of the probate code. So this is a probate code section that talks about how to appoint administrator. So administrator, executor, personal representative, very similar roles, similar to if you have a trust, then trustee, that role. So how do we pick that person if there is no will that specifies that person? So the law goes through a this process of eliminating these people, starting from the closest to you by blood. So or legal relationship. So spouse is the number one, and after that is your children. If they're not available, they're not around, then it goes to your grandchildren. They're not available, they're not around. Other issue means your other linear descendants. They're not around, they're not available, then your parents, and it goes to your siblings and siblings' kids and grandparents. So it's kind of like going further and further in relationship and blood. Um, and then at the end of this whole list, there are some disturbing people, such as public administrator, creditors, and any other person. It's actually written in the law. Any other person could be potentially your administrator. That's scary, and that's why we want to avoid this because this cookie cutter solution does not look ideal. All right. So another example, very similar idea, is that it's also showing that same difference by relational closeness, just in a more visual way. So the person and then children and then linear descendants, then go to the next, which is parents and siblings. So it goes further and further. So if you don't specify a beneficiary in the will, um, then and then you don't have a trust set up, it goes through probate, and the probate court has to rely on something like this. And if all these people are not around or they don't want to deal with inheritance, your treasurer may end up with third cousins thrice removed, and who knows who that is. So that's what I mean by stranger-like beneficiaries. Very real concern. All right, so I'm gonna show another chart, and it's gonna be a little hard to see or read, but don't worry. This chart is just a diagram of the probate process that we've screenshot from the Alameda County Court website. And it just goes to show that there are many steps and deadlines involved in the probate process that you rather avoid. And having a trust set up will help you avoid this whole process. Okay. I mentioned statutory fees in a few slides ago, and this is where in the probate process, there's legally guaranteed compensation for administrator slash probate attorney. And it's just to kind of put the dollar amount in a more visual way, but the idea is that it's a lot of money that's guaranteed to the people that are in the probate court on your case, which you can avoid by having a trust. All right, so now we're gonna do quiz time. We have a well, not quite quiz time, but almost quiz time. So this is an example that shows the comparison of trust versus probate side just through a fact pattern. So imagine a decedent leaving behind an estate that's $1 million. And let's just assume for the sake of simplicity that all there is in the estate is a house. So imagine the house on that date of death fair market value. So FMV stands for fair market value. Is $1 million, and let's say there's 300,000 unpaid outstanding mortgage, and the net value then is 700,000. And let's say cost of an administration, so staging the house, posting this house on Redfin or the internet, all of that is 20,000. Then you have a net balance of 680. If the house is owned by the trust, you can technically start distributing that balance with this number to your loved ones. All right, and this is the trust side. Let's go to the right side, which is the probate side, means this house is not held by the trust, but either mentioned in the will or no will. Same gross fair market value, $1 million. Same unpaid mortgage, 300,000. Same cost of administration, 20,000, with the same balance of $680,000. You will have to account for statutory fee to the person representative, which is coming out to be around 23,000 here, hefty fee, and same percentage, same amount to the probate attorney, which brings your distributable balance to only $634,000. So very significant difference between the left side and the right side. So okay, now it's quiz time. Now that you've learned this concept from multiple angles, we're gonna quiz. All right, we're gonna play Dear Judge Judy, and look at Pamela's estate here. Pamela passed away on March 31st, 2018, leaving behind these things. A house that's worth 300,000, titled as Pamela, trustee of the Pamela Trust, dated Christmas 2007. 2 IRA account with 145,000 in total, naming Ben as the beneficiary. Life insurance of 70,000, naming mom Stella as the first beneficiary, and younger brother Leo as the second beneficiary. And Stella passed away the year before Pamela. And also she has left behind checking and savings account with $2,000 in the balance, naming boyfriend Tommy as the beneficiary. So the question is, dear Judge Judy, does Pamela's estate need probate proceeding? I'll give 5 seconds for people to ponder. And the answer is no, it does not need probate because Pamela has done her homework. The house is owned by the trust, as you can tell from how title is held, and the retirement account has a named beneficiary that outlived Pamela. The life insurance policy had two beneficiaries set up. The first person, the primary choice, predeceased Pamela, but the second choice, Leo, was still around and was able to receive that gift. So no probate there. And then the checking and savings account with money in there and naming a specific person in there to receive the benefits. Even though Tommy is not married to Pamela, it doesn't matter. All right. The second Judge Judy question is concerning a gentleman called Alex. Alex and Pamela has seemingly very similar estate makeup, where there's a house of the same amount of um, gross value on the date of death, but different way of holding title. It's titled in Alex, an unmarried man, to IRA accounts um, with no beneficiary designated. Life insurance, naming Father Sean as the first named beneficiary, but no second beneficiary. John died 2 years before Alex. Checking and savings account, naming my girlfriend as the beneficiary. About 20 people claim to be his girlfriend. Now, does Alex's estate need probate proceeding? I'm gonna give another 5 seconds. And the answer is, unfortunately, yes. The house is not in the trust, therefore subject to probate. Two retirement accounts with no beneficiary, subject to probate. Life insurance naming father as the beneficiary, but father died before him, and no secondary beneficiary, subject to probate. Checking and savings account naming my girlfriend as the beneficiary, but it's ambiguous. Who is the girlfriend? Subject to probate. All right, hopefully you've made the right choices and learned the concept really well by now. And I will talk briefly about transfer on death deed. So if you recall earlier when I talked about exceptions to probate, there are these bubbles that showed up. One of them is the living trust, and the other one of them is transfer on death deed. And I'm gonna jump real quick to this slide to show you an example of transfer on death deed. So about half the states in America has adopted transfer on death deed as a accepted way of estate planning. So what this is you already have a deed that shows your title to the house. The transfer on that deed is looking a lot like the deed that you already have, assuming you're a homeowner. But a key difference is that there is a part on the left bottom that says beneficiary. So you could designate a beneficiary, one person or two or more, to be the ones receiving the house after you pass away. So you can tell this is a straightforward way to keep the house from probate. And you can do this in lieu of the living trust. Um, but then there are some limitations and kind of unique characteristics about this document that you wanna discuss further with the estate planning attorney you work with. Just very briefly, there are some eligibility requirements for the transfer on that deed. It has to be real property that's like less than 4 residential dwelling units, and so there's like that limitation of it could not be like a giant apartment complex that's using this for estate planning. And usually single family homes will be eligible. And then if it's a farmland, it cannot be more than 40 acres. And so there's these parameters uh, that associated with the transfer death deed. There's also formalities requirements. Beneficiaries must be identified by name. That's understandable. And it also has to be signed, dated, and recorded within 60 days after notarization date. So that's kind of a strict requirement. It's very easy to miss that 60 days. Unless you are really on top of it, where you sign and notarize and remember to record it right away. And then if later on, say you change your mind, I want to do a full-on trust instead of this transfer on that deed, you have to do another document just to revoke the transfer on that deed, and it's the same formalities requirement for that one, where you need to sign and date and notarize and record that revocation 60 days after notarization happens. So that's what I want to talk about for transfer on that deed. So at this point, we're done talking about the inheritance planning instruments that include trust, will, and we talked about probate proceedings and why we need to avoid it. We also talked about a alternative to trust for houses specifically or real properties specifically, which is the transfer on that deed. So now we're going to talk about what happens when we're still alive but not able to take care of ourselves. As you may recall, those documents consist of power of attorney for financial purposes and advanced healthcare directive documents. They're only relevant during lifetime. So for both power of attorney and healthcare directive documents, they are an important part of your estate planning process. It allows you to plan for incapacity by naming people you truly trust to make necessary financial, personal, and healthcare decisions. It gives you rooms to describe your desires about future care. You can go into very granular details about your preferences for using artificial nutrition while in a coma, or for POA, it's power to make annual gifts for estate tax reasons. And you can use it to talk about your preference for in-home care over facility. There's a lot of room to personalize to your liking. And perhaps the important idea is that you want to have these documents set up not just to name very specific preferences, but you're actually trying to avoid another costly court proceeding called conservatorship. And not just costly in the financial sense, conservatorship proceedings, as you might have heard in even popular media, might be quite conflict driven and emotionally involved proceeding. And you just don't have to go through that if you already set up the documents while you are healthy about your intentions, about who to take care of you when you are not like, able to take care of yourself. So for POA, power of attorney, um, the roles in that document will be the principal, which is the person setting up the document, and the agent, who is named as or called attorney in fact in the document. And there are powers that are springing versus imminent. In our setting, you almost never give so-called imminent powers, which just means even if you name your adult son as the POA, it doesn't mean your adult son can start taking money from your account today. Only after you become incapacitated, not able to take care of basic needs for yourself, At that point, when the doctor determines that you have lost capacity, then um, your son's power that you've granted kind of just springs into action at that point. So that's what these terms are trying to um, refer to. And then with the authorities that you grant, you can limit the scope, or you don't have to limit the scope if you trust that person 100%. So there are flexibilities there too. So for both POA and healthcare directive, you want to name a primary agent and a secondary. And if you want to name more backup options, feel free to do so. You want to ideally choose someone who is assertive and someone who's close by, especially for healthcare. And you have to pick an adult. And it's a good idea to every 2 or 3 years give it another look to see if you want to make changes. Um, and sometimes people think about having co-agents, so more than one person acting at the same level, always making decisions together and having to both sign off in order for something to take effect. We in general don't recommend that just because it gets complicated. Um, yeah, just to lay it out there. And um, having these documents set up or trying to set it up is also a good chance to have some important conversation with your loved ones about your intentions about the future. So tough conversations, but it has to happen at some point. And when you set up these documents, it's a good segue into having those tough conversations. Briefly about conservatorship, which I said we're trying to avoid. What is it? What it is that if you become unable to make sound choices, feed or dress yourself, handle your own finances, pay the bills, file tax return, hire caregiver with the money that you withdraw from your account, like these things, um, you cannot do these things anymore, or you have a hard time resisting undue influence, a caregiver that might want to tap into your account, like those kind of things, you become vulnerable to those kind of um, challenges, then the court will want to appoint a conservator to manage your personal and financial affairs on behalf of yourself. And similarly to probate or any other court proceeding, the court supervises each action and the decision of the conservator, which means more time and more money. And just to steer you a little bit further, if needed, um, the court might also decide, okay, it's necessary to place the conservatee, the person being conserved, with dementia or some other conditions in a locked facility. So basically, the idea is that you may lose control sooner than you realize in a degree that's like hard to fathom if you don't set up the arrangements yourself ahead of time. So in the healthcare world, there's also other type of arrangements, um, post form, which looks like this, and ENR, the do not resuscitate form, that looks like this. So these are other things for other specific purposes that you may get recommended to set up. And they're just not the same as your advanced healthcare directive, but together with your advanced healthcare directive, they could map out your healthcare plan, or what happens, who to contact when emergency occurs, that kind of thing. And yeah, and there's also End of Life Option Act, which is a very narrow scope assisted death procedure. So something to, if you're interested in more detail, something to discuss with your doctor. All right. So at this point, we talked about the basic documents that go into your estate planning packet and the timeline, the parameters, and the differences and similarities. And if you are interested in setting up these documents, you want to then meet with a estate planning attorney. And if you are married, to meet the attorney with your spouse together. And you, in that process of meeting with the attorney, you provide personal and financial information so that the attorney can draft documents for you based on your situation. And you do some back and forth with the attorney in terms of the details that you want to change and mistakes to correct. And finally, you are satisfied with the draft. Then you execute the documents in front of a notary public. And at that point, your documents are legally effective, but that's not the end of the process. You want to fund the trust, and the details of it you can discuss with the attorney. But basically, for example, the house that we talked about, Pamela had a house in the trust that on the deed it says Pamela, trustee of the Pamela Trust. So she did something there where the house is now in the trust. So that's called the funding the trust. So you want to do that with the attorney together. And then after the documents are set in stone, as I said earlier, it's a living document. It's supposed to change as your circumstances change. Here are some celebrities where they did not update their documents accordingly, and they passed away without having done what they should have done with their documents. So, um, so for example, Barry White here separated with second wife and lived with his girlfriend who tried to claim inheritance but had no right. The second wife, who is estranged long ago, took it all. So that's because he didn't update documents to reflect the current relational dynamics, and we don't want to copy the mistakes. All right, so here's Hera's contact information, and you can feel free to call the number if you want to know more about the process and how you can work with one of our attorneys on the estate planning team. And you can also email this email address if you want to learn more. I'll keep this slide up. And are there any questions? Maybe we can address some questions at this point.
Thanks so much, Irene. There are a few interesting questions here. Um,
Mm,
First, just really quickly, this one came in when we were discussing the roles of the trustor and the trustees. The question is just, can the trustee also be one of the beneficiaries?
the answer is yes, and it happens quite often, especially in like a family setting where the parents set up the trust and they have their adult children act as both trustees and beneficiaries. So yes.
Definitely, definitely. And two more questions so far. This one is asking, are there any downsides to setting up a living trust?
Mm, downsides. Trying to think. So I would say not everyone would need it. For example, if somebody's estate size or everything that you own on the date of death together, gross value is lower than the threshold that I mentioned, which is roughly 200,000, then setting up a trust is kind of a waste of money there, just because setting up a trust typically takes um there's a cost, right, with setting up the trust, even though compared to the probate, it's a small cost. But if you already do not have a big enough estate to even worry about probate in the first place, then you don't need it. Other than that, um, yeah, I don't see other hardcore um harm to setting up the trust. Yeah, but it's still worthwhile if you wonder. You can discuss with the estate planning attorney that you choose, and bring to the attorney your specific um asset makeup and circumstances, and see if you will benefit from the trust.
Great, great. And then this one kind of even relates to what you were just saying. It's just simply, does the asset value actually include both the value of the house and the retirement accounts?
So retirement accounts, we usually do not put that into the trust. So retirement accounts, if it has a beneficiary designated already, it's outside of probate. If that's the so when probate court takes account of a decedent's estate, they look at what probate assets you have. So so if the house is not in the trust, that's accounted for as probate asset. And if, a retirement account doesn't have a beneficiary designated, that's also a probate asset. So they would be accounted for. But if the house is in a trust already and the retirement account has beneficiary designated, then neither of them is a probate asset, and that person doesn't have, assuming there's nothing else, the person doesn't have probate asset there, if that makes sense. So depending on how um the title is held, and also if they're already beneficiaries designated.
Gotcha. And then one more question just came in. It's a two-part.
Mm,
First, as far as Harris services, if it's a low income senior, would Harris be able to set all of this up for a low cost? And can the plan be done without relatives, only a professional to administer?
I see. So the short answers to both questions would be yes. So we do have a sliding scale fee schedule um, for clients that come in based on their income level. We will have a different quote for fees and costs. So you can feel free to reach out to us, set up an intake call, and when you speak to the attorney on the team, you will get a quote based on your income level. The second part of the question about um, having only professionals involved and no relatives. Yes. In California, there is a association that um or a licensing agency that issues licenses to something called professional fiduciaries. So people who get hired to do the trustee's job or executor's job. Um, and some of them would be paid by the hour they work. Some of them have like a different kind of a fee schedule. But yeah. So people, when they don't want to involve any relatives, they can choose to hire a licensed professional fiduciary in California.
Got it, got it. No questions for now. Everyone just feel free to put your questions in the Q&A box. If there are any more questions? But yeah, no questions for now.
Okay, sounds good. I guess then we're done. And let's see if I have one more slide. So okay, so this is the slide that has both library resources as well as para resources. yeah, feel free to copy down or take a picture or screenshot of anything that could be helpful. And if there's no more questions, I think we could dismiss.